Good afternoon, Your Honors. My name is Andy Murphy, and my co-counsel is Brianna Coyle. Together, we represent the petitioner in this matter, Larry Manitowoc. With the court's permission, we would like to reserve 3 minutes for rebuttal. Thank you. There are 2 issues on appeal today. First, whether the Rabbit River Tribe retained regulatory authority over our client to issue him civil citations and confiscate his property. Second, whether the tribe possessed adjudicatory authority to issue a civil contempt order that deprived my client of his personal liberty. I will be addressing the first issue, and Ms. Coyle will be addressing the second. On to the first issue. The Rabbit River Tribe lacked the regulatory authority to issue civil citations and confiscate my client's property.
Counselor, why does this court have jurisdiction in this case?
This court has jurisdiction for, and Ms. Coyle will be addressing that more directly, but it has to do with the Santa Clara Pueblo case that granted the federal court review over civil matters within the tribal court proceedings. And even though the court ultimately ruled that the tribe had civil authority within the tribe, it was able to review that. Additionally, there are the due process claims that my co-counsel will address more fully. However, the fact of the matter is that our client had substantial due process violations, and that would bring it into the federal court review.
Are you saying there's a writ of habeas corpus under the Indian Civil Rights Act?
We would say that there is functionally a writ of habeas corpus.
What does that mean, functionally?
And this is something my co-counsel will be more prepared to address fully. I was intended to address the regulatory authority, but to answer your question, our client challenged the tribal court's jurisdiction in the tribal courts and has done it through every step throughout the federal process. Additionally, because this case was already brought in district court, and this court should be able to rule or adjudicate the district court's ruling, as it was already into the federal system. But in regards to the regulatory authority over our client, we argue that the tribe lacked it for 3 reasons. The first is the tribe lacks regulatory authority over non-members on fee-like land. The second is that the tribe, the dispositive factor for regulatory authority is membership status, not land status. And third, the tribe's ability to self-govern its members and maintain internal control was not affected by our client's behavior, and therefore the Montana exceptions do not apply. My first point, that the tribe does not retain regulatory authority on fee-like land. Fee-like land was defined within the Strait case, where there was the road that ran through tribal trust land.
Counsel, I never heard the term fee-like land. I mean, did this take place on trust land?
It happened in a parking lot on the casino, and we're suggesting that the parking lot is functionally the same as the road that was in the Strait case, because the court identified 5 factors in Justice Ginsburg's unanimous Supreme Court decision that ruled that even though the road ran through trust land, it was a right-of-way and the tribe lacked regulatory authority. I will proceed with identifying those 5 factors. However, the real test here is that fee-like land is where the tribe forfeits or alienates its rights to exclusive right to occupy and exclude. You have to use it or lose it. The best example of this is the Brendale case, where when the tribe attempted to zone both trust and fee land, there was a divided decision as to where they could and where they could not. This followed Montana's divestment of regulatory authority over fee land, and importantly, the tribe was able to regulate on fee land because they exercised their right to exclude. In the area that was trust land, the tribe was not able to regulate it because it was open to the general public. They did not exercise their right to occupy and exclude, and therefore they forfeited their right to regulate. The same happened in the parking lot. Justice Ginsburg identified 5 factors that demonstrated that the highway was a right-of-way where the tribe lacked regulatory authority. Those factors are consent, use of the right-of-way for the consented purpose, compensation for the right-of-way, availability of the right-of-way to the general public, and the lack of exercising of the gatekeeping power.
Where is the right-of-way in this case?
The right-of-way is the parking lot, Your Honor.
And I'm sorry, where in the facts do you see that it was a fight in a parking lot?
When they were on their way from the casino into the parking lot, that's where they were detained. That's where the tribal police, it's unclear from the facts, but it's clear that it appears as if it did not occur in the casino. Because when the tribal police were coming to detain my client and Dickie Dare, on their way they saw the truck where the controversial materials were.
Counselors, is the key aspect here of your analysis to the right-of-way the fact that it happened in the parking lot? And if so, how can you make that argument given that it's not clear from the facts?
Your Honor, yes, it is our argument that because it happened in the parking lot, it is a right-of-way. And because it's also not clear that it happened in the casino, then we infer that because the tribal police on their way to the truck saw our client, that we believe it happened in the parking lot.
Counselor, do you have any case law saying that a parking lot constitutes a right-of-way?
No, Your Honor. However, there is an important element within this Drake case where Justice Ginsburg left the door open as to whether a car accident or some sort of other controversial conduct occurred on trust land, whether the tribe would have regulatory authority over that matter. She left the door open and they could have closed it. We argue that this is the situation where conduct would occur on trust land and that does not count, that would not qualify for regulatory authority, specifically because they did not exercise their gatekeeping authority in the parking lot.
But isn't there a difference between a state highway that runs through a reservation where people are just passing through, perhaps not even meaning to stop at the reservation, and a parking lot on land that's trust land, and individuals like your client who are specifically coming to the reservation to avail themselves of the casino? Isn't there a distinction between a state highway that runs through and a parking lot where people stop and avail themselves of tribal facilities?
Your Honor, there is a distinction. And what you have identified is precisely the distinction. A highway allows for people to run right through the reservation, and a parking lot is somewhere where they stay and avail themselves of the tribe services. However, the defendant in this Drake case was not just running through the tribal reservation. He was a contractor who was visiting the tribal land for a landscaping job. He wasn't just driving through the reservation. He intended to stop and avail himself of the tribe services, specifically a paycheck. And that was not enough to grant regulatory authority over him.
Let me ask you, if the events have taken place inside the casino, you wouldn't be contesting the jurisdiction?
Yes, we would not be contesting this decision.
Don't you need a parking lot for people to get to the casino? What's the difference between the casino itself and the parking? Isn't that part of one big structure? You need a parking lot to get there.
The difference, Your Honor, is the lack of a gatekeeping authority. Had the tribe merely placed a gate at the entrance of the parking lot, that would be enough to occupy and exclude. Had they put a sign notifying those that when they enter the parking lot, they'd be subject to Rabbit River tribe regulations, that would be enough to exercise the right to occupy and exclude.
You're saying that a casino with a gate at the parking, vis-a-vis casino without the parking, everybody knows the parking, the casino uses the parking, but there's difference, it would be different results?
Yes, we draw a distinction between the parking lot because it follows the 5 factors that were outlined in this Drake case from the conduct that would have happened in the casino.
What if I have a casino and the gate falls down? There's no gate, where would we put that?
We would suggest that that's, our position is that the security guards that were in the casino function as an exercise of gatekeeping authority. So had the casino had any sort of security enforcement, that would qualify.
But it was the security guards.
No cases, this gatekeeping stuff, does that appear in any case?
The gatekeeping authority language appears specifically in this Drake case, and
At what page?
I'm not sure specifically. Oh, it's on 455, 455 to 56.
Because I think the whole thing in the straight case was just sort of expectations. Anyone on that highway, if you would ask them, are you on a state highway? The answer would be yes. If you're parking in a casino parking lot and you ask, are you parking in a tribal parking lot? What other answer would they have except yes?
I'm not sure, Your Honor, but I think that,
Okay.
whether they were on tribal trust lands or whether they were on a state highway, the facts that we are arguing is that the 5 factors that Justice Ginsburg outlined to create a right-of-way are consistent with the parking lot in this issue. However, if you don't believe this argument, the tribe doesn't have a regulatory authority over my client for a second reason, my second point, and that is that land status is not dispositive, membership status of the unconsenting party is. There is no binding authority for this court to rely on where a non-consenting defendant has been subject to tribal regulatory authority.
But the whole point is that's why we're here. I mean, the whole notion there is no dispositive test. I mean, if there was a dispositive test, you could say it, we could see if it was satisfied or not. I mean, it's Montana, and Montana doesn't tell us what is or isn't dispositive. I mean, isn't the thing you have to look at everything? If the land is relevant, the status of both the parties is relevant. I mean, isn't that the kind of stuff?
Yes, Your Honor. I'm sorry, but is there more to your question?
No.
Land status is an important factor. Party membership is also an important factor. Land status is not dispositive. You also have to look at the conduct in the Montana exceptions, which are my third point. The important element